The word weighs something. There's a difference between a right and there's a difference between a duty. And a lot of parents don't understand that. Oh, rights and duties, they don't understand how much that word duty means. That's your obligation. And the state will hold you to that obligation of child support. But when Alan has a duty for care, control, and protection of his child, and he wants to file a criminal complaint, they're obstructing his duty to protect his child. So while you use duty to support, right, Alan, you better support your child. You better pay that child support. That duty isn't really worth anything when he tries to use it for his care and control and protection. So if the judge denies you the duty or is obstructing your duty, but wants you to pay child support, but now you have a duty to protect your child too. That's in legal proceedings. That's out in the public. That's to fight false allegations. That's to allege child abuse. You have those rights. And not only is that your right, but it's also your duty, your obligation to your child that you protect her.
Yeah.
I protect her.
I've had 2 judges deny me a hearing for a protective order. They're supposed to set the hearing upon the filing. So immediately. Why would they deny me a hearing for protective order if I need to protect my child?
So in the 257th with Sandra Peak, same thing. She denied me a hearing for an enforcement. If you look in the enforcement chapter of the Family Code, it says the court shall set the date. I used to call the court clerk coordinator and try to schedule, and she would not get back to me. She would not email me. The law says right there, the court has to set the date of the enforcement.
So on issues like this, especially where the word shall is used, we need to take that up to the appellate court and then up to the Supreme Court to see if I have a right to a protective order hearing.
But it should, but what my issue here is, it shouldn't even get that far. If you're a judge on the bench and you don't know what may and shall is, and you're suspending a habeas corpus from a pro se litigant, we have a problem. Like, you need to get off that bench. You're not qualified. You're going to hurt more children with your incompetence because you don't know that you have a constitutional right for a habeas. No habeas shall be suspended. Right. And the same thing with the enforcement, and the same thing with your issue.
It sounds like deprivation of rights under color of law.
Well, again, right. It does that on the federal level, but on the state level, that's official oppression or abuse of your official capacity. Now you're denying Alan that. Why are you mandating he go to the Supreme Court or the higher courts? You have a tablet at your disposal. You probably have a staff attorney in 2025 that can look this up. And you're still denying this guy? That's oppressive.
What's awkward about that is one of the judges had to go back to his chambers for about 30 minutes before he could decide to deny the hearing. I mean, that just seemed very unusual, that he had the family code in front of him. He had his computer in front of him, but neither
he needed to go take a nap.
I think he went back to make some phone calls.
But if you're going to run for judge, and we're in re-election time, if you're going to run for judge, and you don't know what the hell you're doing, you shouldn't be a family court judge. If the family court judge doesn't know what interference with child custody is, they don't need to be on the bench. So many cases are taken to family court for possession and access. If that family court judge, district court judge, does not know that taking or retaining the child in violation of that court order is a state jail felony, that family court judge does not need to be on the bench. Because that's all these family court judges see: possession and access and child support. When a parent comes in and says, man, I haven't seen my child in 4 months. Red flag. What's going on? Why is this happening? My ears should perk up. Well, he doesn't want to go with his dad. Now they're just stringing everything else along. Alan's got to ask for a hearing. George is asking for an enforcement hearing. And they have all the technology and they're still not using it. And they're depriving us. That right there is oppressive, especially in 2025. No excuse for it. These judges are not looking up the law because they don't know it.
Or if they do know it, they're not applying it still.
No, if you know it, you're being oppressive. If you don't know it, at least you can say, hey, I'm incompetent. The Texas Constitution tells George and Alan how to remove me. But if you know it and you're still oppressing Alan and George with your robe, that's oppressive. And that right there, official oppression, is in the penal code, and it says it in the Constitution. You can remove a judge when they are indicted or charged with oppression of a misdemeanor. Official oppression is a Class A misdemeanor under the Texas Penal Code.
So yeah, we can that creates more rabbit holes we could go down, but I think we had a pretty good talk.
I hope so. I'm gonna cut him up. I had a brain fart in the middle of it. Well, at the beginning.